A very good afternoon to everyone for another session on the higher pension eligibility with the new updates that we have got in last couple of weeks, and also addressing the FAQs which we were not able to take completely during our last session. So a very warm welcome to each and every participants, and I've got here with me Mahesh Kumar. Mahesh is our expert on all the legal matters, and I'll request Mahesh to start taking us through the details, and in the mid we can take the questions accordingly. Mahesh, over to you.
Thanks, Sumit. Thanks for the setting up the context. So I'll start sharing the screen. Hope my screen is visible.
Yeah, Mahesh, I think we can start.
Good afternoon once again to everyone. This is our second session on the higher pension eligibility. And as Sumit rightly mentioned, that we are going to focus more on the FAQ part, the frequently asked questions, where a number of employees have coming up with their own the questions where it has been several times addressed, but however, certain queries have been unanswered and which we would like to take it up during this session. So move on to the index. So we are going to touch upon the background of the higher pension and what is the higher pension and what all the ambiguity being raised and why this higher pension concept has come into the picture. And what is a Hon'ble Supreme Court Judgement which has been pronounced or provided the verdict on the higher pension and who are all eligible for the higher pension. So as we mentioned, the FAQ part, we have a detailed FAQ and the illustration which is related to how much is going to be the existing pension and how much, if you opt for a higher pension, how much it is going to be. What would be the difference part, which we are going to also elaborate during this session, and move on to the next. The index part is related to employers' immediate action, what employer has to immediately initiate the action. So more to the background of higher pension. What is the background of higher pension and when was the higher pension was introduced? The background of the higher pension. I mean to say, first I wanted to give the light on the employees pension scheme, which was introduced in the year 1995 and which was enacted and which has been implemented from 16th November 1995. And this is one of the social security scheme administered by the Employees Provident Fund Organization. So when the pension has been introduced in 1995, the PF ceiling was at that point in time, it was 5,000, where the PF ceiling was. Even the pension was contributed on the 5,000 that point in time. So move on to the next point, which is what is para 26(6) of the EPF scheme. So why this higher pension has come into the picture? Where was the gap, or what is this 26(6)? I would like to throw some light on it. What is para 26(6), which is related to, there are industries, those who are contributing on their actual basic or the PF wages of an employee, which is beyond the ceiling limit, which is 5,000, as I mentioned in the year 1995. And subsequently, there was an announcement in the EPF's PF ceiling, which is 6,500 in 2001. And on 1st September 2014, the EPF ceiling has been enhanced to 15,000. So in this period, or during this period, employees, those who are contributing on a higher side, on the actual basic, which is beyond the prescribed ceiling limit as stated here, if employee and employer would like to contribute on the higher side, the employee and employee has to provide a consent. The consent has to be provided, which has to be submitted to the PF department, and same has to be, approval has to be obtained. So that is when this is very, very important para to understand why the higher pension has come into the picture. Similarly, under para 11.3 under EPS scheme, stated that employees who would like to contribute on the actual basic, even the pension has to be contributed on the actual basic. If employee and employee is willing to contribute on actual PF, EPS on the actual PF wages. Again, the same joint consent as per the para of EPF scheme. Similarly, under EPS also, the joint consent has to be provided. So as I mentioned, what is higher pension? So as I stated, those who are contributing on actual basic, which is beyond the prescribed ceiling limit, which in case if employees are contributing on 8.33% of the actual PF, then the higher pension, you will be contributing it. But wherein due to lack of clarity of 11.3, which I have stated in my previous slide, where employers have been restricted their pension to the capping, despite they were contributing on the higher side. So they have, they have restricted PF to the pension to the ceiling amount. So that is when this issue has come up, and where many of the majority of employers were contributing only on the capping to the pension, wherein they were not contributing the pension to the actual basic. So where is the ambiguity? As I stated, the ambiguity raised due to lack of clarity submission of the joint consent to the PF department as per the erstwhile para of 11.3 of EPS, where EPS para 11.3, as I mentioned in my earlier slide, where joint consent has to be submitted, which was not submitted earlier. That's when this issue has come up. Further, EPFO also has not enforced employer and employee to submit the joint consent despite the contribution, like employers were contributing on the higher side. And EPFO also has rejected certain consent which was received prior to 1st September 2014. Certain the joint consents have been received. However, department has not responded, or the department has not provided any kind of clarity on it. That is when the employers have restricted their pension to the capping or to the ceiling of EPF. There was a notification on 1st September 2014, which has extended the time period. As I mentioned, the 1st September 2014, the EPF, the ceiling has been enhanced from 6,500 to 15,000. Subsequently, one of the provision under the notification, they have stated that those who are contributing on higher pension, if they're willing to contribute or continue to contribute on the higher pension, where they have to exercise this option, where the notification has given the window period of 6 months to contribute or to contribute on the pension, higher pension. So provided further, they have stated 1.16% additionally, the contribution has to be paid by employee, those who are contributing on the higher wages, which is, I'll just give you an example. If employees are contributing 20,000 as a basic wages, the remaining 5,000, 15,000, you will be contributing the pension being contributed. Anything beyond 5,000, whatever the difference of amount, where employee has to pay 1.16% additionally to the department. And this is the one provision has been newly introduced in the 1st September 2014 notification. This is where even there was an ambiguity has been created. Even the most of the employers were not aware how do we contribute this 1.16% additionally on the higher wages. Sumit, you would like to add something here?
I think this is a decent change that has come in, and I think it is if executed in a right way, I think it's going to be beneficial for both the employees and the employers in the long run. But the crux of the entire discussion is how do we implement it in the right way? So Mahesh, if you can just explain this highlights in some more elaboration, I think it will be more clear to our participants in this.
Definitely, so thanks for the inputs. And move on to the highlights of Hon'ble Supreme Court Judgement, which is on the higher pension. They have pronounced their judgment on 4th November 2022. Depicting, Supreme Court has stated the window period has been extended. As I mentioned, on 1st September 2014, notification stated higher pension, those who are contributing and willing to contribute, the window period has been provided 6 months, wherein many of the industries or many of the employers or employees have not opted for the higher pension despite they were contributing on the actual basic, which is beyond the prescribed PF wage ceiling. So the Supreme Court has given another 4 months window period from the date of judgment where they can exercise the higher pension, contributing on the higher side. That one additional the provision they have provided. In addition to that, they have mentioned that they have kept this 1.16% for a 6 months period. It is not required employee to contribute towards the higher pension, where they have directed, like Supreme Court has given the direction to the EPFO depicting that the department has to justify why this 1.16% has to be collected from employee, why this amount can be internally adjusted from the EPS board, or same may be collected from the employer. In case like employer, then same has to be justified along with the proper justification or proper details to the Supreme Court. That is when this 1.16% can be collected. But so far, department has not provided any insight on this 1.16%. However, there is a timeline which has provided 6 months from the date of Supreme Court judgment, which is going to be end by 3rd May 2023. By then, the department has to provide the clarity 1.16%, how this amount shall be recovered in near future. Another important the provision or important the judgment given by the Supreme Court is higher pension option extended to exempted establishment as well. This was the department was not entertaining for the higher pension for exempted establishment, and they have clearly called out in one of their notification depicting that higher pension cannot be opted by the exempted establishment. Exempted establishment, those who are operating the trust, which the EPF account being maintained by the own company forming the trust. So such kind of establishment shall not be able to take this higher pension option. However, Supreme Court stated the trust is also as good as the unexempted establishment, and they have to be equally treated, and the benefit has to be extended. So these are all the important highlights of the Hon'ble Supreme Court judgment, which has pronounced on 4th November 2022. I will moving on to the next slide.
So, in this, Mahesh, while we have got time till May, right, for implementing the changes, what do you, as per your legal expertise, how do you think, how can organizations plan, and how much time it will take for organizations to do the right planning, socializing it with the employees to overall create a better employee experience and to give them the right kind of walkthrough in detailing? So that will require some time as well.
Here, what they have cited, no, Sumit, though they have extended the timeline, the portal specifically, what I would like to highlight is the department has stated that exercising the higher pension option has to be done through the portal, which is the URL has been provided by the department, wherein this has been introduced prior, when somewhere after the Supreme Court judgment, immediately maybe after 10 days or 15 days of it, wherein they have introduced from 27th February. So that is when, and the timeline which has provided in the Supreme Court judgment was the 4 months. And it was a very short notice for every employer or to communicate their employees, and employees to opt for the higher pension, they required some time. So that is when the timeline has been extended for another 2 months period. However, here the department is mandatorily requesting for the consent, joint consent, as I mentioned in my previous slide, that para 26(6) joint option to contribute on higher side. The department is demanding for 26(6), where most of the employers are not having the 26(6) joint consent, which was submitted to the department and having the acknowledgement, and department is seeking for this acknowledgement copy as a proof. This has become a major concern for every employer. Now, how do we proceed? If I don't have the joint consent, which was submitted earlier, whether am I eligible? So this is the same question we have even raised with the PF Commissioner. Before the PF Commissioner Bangalore, the PF Commissioner has stated And he has also provided an option, you can proceed, you can attempt and get this for 26(6) joint consent to the department, and same acknowledgement can be submitted in the portal, which would help even department to scrutinize or verify the document and further proceed for the approval. Further, what I would like to highlight is, again, it is depending upon the department to department. Though EPF, it is a centralized act, and all direction has to come centrally, and which shall be applicable, equally applicable to all the states, wherein certain departments are coming up with a different version, stating that no, we will not allow you to submit the joint consent now. You should upload which when you started contributing on the higher side. So this is the one of the major ambiguity or concerns being faced by each and every employer. From team leads, and what we would like to highlight, or what we would like to inform to all our clients or for all our participants, you please go ahead and get this submitted, or in case if department is not accepting, we would request you to reach out to the higher authority, higher person in the department, and make sure you will go and get this submitted. So that's when you can exercise the higher pension option. So this we would like to highlight on behalf of the team leads to all our clients and for all the audience. So I will move on to the next slide. As I stated, certain scenarios, I have come up with the certain scenarios here. Overall eligible for the higher pension, overall eligible as per the Hon'ble Supreme Court Judgement. So we have come up with the first scenario. This scenario speaks about people like employees, those who have retired prior to 1st September 2014, and what would be the scenario of such category. So here there are three categories are there, the three classification. One is, as I stated, contribution on higher side, which is one of the mandatory requirement for you to opt for the higher pension. So the column says here, the third column is pertaining to the capping, those who are contributing above the ceiling limit. So here in this scenario, the first classification says the person was contributing on higher side, wherein he has not exercised the option. Where, as I mentioned, the joint consent was not submitted as per para 11(3). Such category of employees will not be applicable for opting the higher pension, which was very clearly called out in the Supreme Court judgment. So I have mentioned in my the remarks column as well. And another category of employees retired prior to 1st September 2014, and they have exercised the option, they have submitted to the department, wherein department has not clear, like they have not responded to the application, joint application submitted by such category of employees. Now such category employees can go back to the department and exercise this option, higher pension option. So this second category of employees will be eligible for going for a higher pension. So move on to the third one, the employees, the category of employees, those who are not contributing higher than the prescribed ceiling, they were contributing to the ceiling or less than the ceiling. So such category of employees anyways will not be eligible for higher pension. So move on to the second scenario, which I have stated here. The second scenario speaks about people were contributing on higher side prior to 1st September 2014. Even after 1st September 2014, continue to contribute, wherein they have left the organization after 1st September 2014. So what would be, how such category of employees will come into the higher pension bucket? So we have stated here again, three scenarios are there. The first scenario category of employees, they were contributing on higher side, wherein they have not exercised the option. Will they be able to exercise their option now? Yes, they will be able to exercise the option. The submission for exercising the option, as I mentioned, 3rd May 2023, they can proceed. Another category of employees are here. They have a contributing on higher side. They have also exercised the option to the department, wherein department has rejected the claim or they have not responded. Such category of employees also will be eligible for opting the higher pension. The third classification, which I have stated anyways, they were not contributing, will not be eligible. So move on to the third scenario. This is very important scenario, and the existing employees, how do we deal with the existing employees? Employees were joined prior to 1st September 2014, and they were contributing on the higher side, and they are continue to contribute until they are working in the organization, and they are the member of the EPS. How do we proceed for such category? We have again 4 categories here. The first category, they were contributing on higher side, prescribed the ceiling limit, and they have exercised the option. Either way, again, the joint consent was not responded by the EPFO. Such category of employees will be eligible, which the exercise has to be happened now. The another classification is they have not submitted any joint consent, but still such category of employees will be eligible. They can also go and exercise their higher pension option. And third category of employees, those who are not contributing. This I have taken just for an example to give you more insight. So those category of employees anyways will not be eligible for contributing on higher side. And coming to the 1st September, people who have joined, this is very important point. I would like to throw some more clarity on this. Employees, those who have joined on or after 1st September 2014, and joining as a first time to the EPF membership and whose PF or basic wages is more than 15,000, they will anyways not going to be eligible for pension. So we need not to worry about such category of employees. They will be anyways going to move out from the EPS. So such category of employees will not be eligible for the pension at all. This is one illustration I have come up. I would like to give you a detailing here, make you understand how the employee, like when you opt for a higher pension, how much is the benefit which you are going to get it. And this is the illustration. The first table speaks about contribution on the PF wage ceiling. If employees are contributing on wage ceiling, I have considered 15,000 as one of the wage ceiling and another wage ceiling as a 6,500, which is prior to 1st September 2014. And the person who has put in service of 20 years, he has put in service of 20 years, and how much is the pensionable, pension is payable to him. So I'll tell you how the pension calculation happens so that you will be able to understand this table easily. The calculation is the 60 months, which is a 5 years of average EPS wages into number of years a person has served divided by 70, which is a lifespan. So that's how I have considered 15,000 as an average balance, which anyway is not going to be beyond 15,000 because the capping is 15,000. That is when we have mentioned as a 15,000 as the average EPS wages, and person has put in services of 20 years. What would be the pension, which is 4,286 rupees, where employee is eligible to receive the pension. And second scenario I have mentioned as a 15,000, wherein you will have the difference in the higher pension, which I will take you through. Another is 6,500 in case if person was contributing on 6,500. The pensionable amount would be 1,857. So now how if employee who's going to opt for a higher pension, the person who was whose PF wages was 80,000 and the entire 5 years was 80,000, I have taken average balance as 80,000. If the same person has put in service of 20 years, what would be the pension? The pension, it is going to be 22,857. Wherein in other scenario, the capping, when person is contributing to the capping, what was the pensionable, which was 4,286. Now difference is 18,571 rupees. The difference amount will be like the employee when exercise the higher pension. So he will be receiving 18,571 rupees more than what he was getting later. Similarly, I have also calculated in case the basic wages, the average wage is 40,000. What would be the amount? The again difference is more, and 20,000 also the difference would be more. But what I would like to highlight here is it is very important for you to understand the corpus which is there. Currently, how much you have contributed towards the pension, how much you will be contributing towards the pension when you opt out for a higher pension, which I have mentioned in my table 2. In the table 2, what I have stated is now we are contributing on a capping. In case if capping, if I would have contributed for 20 years, the pension amount, I would have been contributed 2,99,880 rupees for the first scenario. If I opt for a higher pension, how much I have to contribute towards the pension, which is 15,99,360. Since I have already contributed 2,99,000, the difference of amount which I have to contribute 12,99,480 rupees, which is the huge quantum which is being there in the corpus of EPS. So from the EPF account, the amount which is 12,99,000 has to be diverted to the EPS account. So all these while this amount was bucketized under the EPF account, which is account number 1, wherein once you opt for a higher pension, So you will have to contribute 12 lakhs, 12,99,480 in the scenario 1. So you will have to contribute from your EPF corpus to pension. That is when you are entitled to receive the higher pension. So this is very important, and you have to have your own calculation based on your experience or based on your basic wages or the PF wages you have been earning since 5 years, and the calculation has to happen. And that's when you will be able to understand, am I going to get benefited from opting a higher pension, or do I have to contribute more? So this is when I have taken the higher wages also here. 80,000, what would be the difference? 40,000, what would be the difference? And 20,000, what would be the difference? So this much is the difference amount. Once you contribute from EPF to EPS account, that is when you are entitled to receive the higher pension. So more on to the frequently asked question.
Mahesh, I'd like to comment.
Yes.
While Mahesh, we have given a great illustration here. For all the participants, what we will request is that, while you can take an understanding, or this is just an illustration, but before actually calculating and finalizing, you can actually have, an expert view on this, or get it validated before submission, so that the employees can also be have a clear visibility, and the calculations are also correct as per the judgment. So we are more than happy to help you in hand-holding through this, because the timelines of course has been extended for 2 months, but really for a beneficial and the correct calculations and the visibility, Mahesh and our entire team at Team Leads HR Tech will be more than happy to handhold and take you through the details, through exact calculations, etc., for your employees.
Yes, so much. And also what I would like to highlight is, this is a calculation which we have done based on the wage which I have cited. But however, once you exercise the higher pension option and once you are eligible, department will do a calculation how much amount has to be paid. In case of any deficit, the department will ask you to contribute the remaining amount. Otherwise, the department will do a proper calculation and they will notify to you how much amount has to be paid, or how much of the amount which has been transferred or diverted from the EPF corpus to EPS. So that information department will also provide. Accordingly, we will have to take it further step. So more on to the frequently asked questions. We have been receiving several questions from our clients and also from other source. So we have narrated certain questions based on the queries have been received. So we made a certain questionnaires here. So I'll be going through it, and I'll also give you detailing what is the frequently asked question. The first question is related to whether those who have retired before 1/9/2014 can opt now. This I have also mentioned in my previous slide. Those who have retired before 1/9/2014 can opt now if they had opted for a higher pension. As I mentioned, if they would have submitted a joint concern prior to 1st September 2014 and was retired, so such category of employees can opt it now. Otherwise, it wouldn't be. So they will not be able to opt for a higher pension. So more to the question number 2, whether those who are retired on or after 1/9/2014 are eligible to opt now. Those who are retired on or after 1/19 can opt now if they were contributing to the EPF on an actual basic. So there are certain category of employees also may reach out to you. They were contributing only on capping. Maybe they were not aware that they were contributing on a higher side. Still, they will reach out to you. Such category of employees will be can opt for a higher pension. No, those who are contributing only on capping or anything less than the capping will not be eligible, because they were anyways contributing 8.33% of their actual basic, which is ceiling or less than the ceiling. Whether those who are presently working can opt now. Yes, if the member joined before 1/9/2014 and continuing and is contributing on a higher side, which is the answer. If you can refer to the answer 2, yes, such category of employees can also opt for a higher pension, provided they were contributing on a higher side even prior to 1st September 2014, after 1st September 2014 as well, even till now. Whether those who have joined after 1/9/2014 as a first-time membership to EPF are eligible to opt now. No, they are not eligible. As I stated, those who are having beyond 15,000 of basic wages or the PF wages, anyways, they will not be are going to be eligible for pension. Such category of employees will not be able to opt for a higher pension. What is para 26.6? As I stated, 26.6 is related to the joint consent, which has to be submitted by employee and employer together and has to be submitted to the department, and same has to be approved from the not lesser than the rank of EPFC. This is very, very important. Though it was not submitted earlier, I would request all our audience or the participants. So when you engage or when you recruit people or when people have joined your organization, those who are contributing on more than the prescribed ceiling limit, it is suggested and it is highly recommended you to submit joint consent 26.6. Whether option under para 26.6 is compulsory for opting now. Yes, it is compulsory. Higher pension option can be submitted only if member is contributing towards the EPF on the basic wages and the PF wages higher than the prescribed wage ceiling, as I stated. What is para 11.3 also has cited as similar to EPF scheme. Even in the EPF scheme, this was a erstwhile para, now it has been omitted. It is anyways not going to be applicable. Once you provide the consent on 26.6 will suffice. And 11.3 is not, it is not available. It has been omitted. But people who have exercised the option earlier, they can go for a higher pension currently. What is para 11.4 of EPF scheme? There is a para 11.4 which states, this is again, this has been introduced along with the notification of 19/2014. So the chance to continue to option already, those who are contributing on a higher pension prior to 1st September 2014. So even after when you want to contribute, they had given a 6 months of provision, and this para has been introduced 11.4, and they have stated within 6 months window period, you have to give a joint option for contributing on higher side. And further 6 months have been extended by RPFC, depicting in case if there is any ambiguity in the application, they have provided another 6 months time. So move on to the question number 9. If a member who had opted under para 11.3 not renewed his option within 1 year, what will happen? So if member who had opted for a para 11.3, as I stated, people who are prior to 1st September 2014 and not renewed his option under para 11.4 within a 1 year, they will not be entitled. So the department has very clearly mentioned in the 1st September 2000 notification, and they have given a window period of 1 year if they have not opted. So such category of employees will not be eligible for opting a higher pension now. If member opted under 11.3 and not renewed his option under 11.4 within 1 year, can opt now. So no, the same question, it is as good as the question number 9. So I'll move on to the question number 11. Who are not eligible for higher pension? As I've stated, those who have left the organization before 1/9/2014 without exercising the higher option, which is the joint consent of 11.3, those employees will, such category of employees anyways will not be eligible to opt for a higher pension. And those who are contributing towards EPF on the statutory limit, as I stated, if they are contributing only to the capping or less than the capping, they are not eligible. And those who are exercise the option under para 11.3 but not renewed within 1 year, as I stated in the question number 8, so they will not be eligible. And those who have joined on or after, which I have stated, on or after 1/9/2014, the first time membership to the EPF will not be eligible for pension for opting for a higher pension. I mean, it's a higher pension. What is the timeline extended by Hon'ble Supreme Court to exercise the option? The Hon'ble Supreme Court has given the option of 4. They have given the window period of 4 months from the date of judgment. However, further department has extended another 2 months since the portal was introduced very recently. So they have extended up to 3rd May 2023, and which is currently it is going to be 6 months from the date of judgment. Employees, those who had worked in multiple companies, can they exercise higher pension option? So this is one common question we have been receiving it from all our clients or from, so how do we proceed the employee who has worked in a multiple companies? The first scenario here is yes, even such category of employees can also opt for it if the PF or the amount, like the contribution being made on a higher side, the prescribed ceiling limit in entire tenure. In any of the tenure, if he has contributed to the capping or less than the capping, then he will not be eligible. Otherwise, if he would have contributed on the higher side in all the companies, yes, he will be able to exercise for the higher option, provided the EPF or EPS accumulation has to be transferred to the existing employer. It is not that I'm having 4 accounts. All my 4 accounts have not been transferred to my current organization. In such scenario, you will not be able to exercise the option. This is very, very important. Please do educate your employee where he has to get transfer entire accumulation to the existing employer. So move on to the question number 14. What if employee contributed to PF wage ceiling in one of the company and other companies above the ceiling and vice versa? What would be the scenario? This was also being asked several times by our clients, and whether such category of employees are eligible for higher pension. Here it is no. In one of the tenure where employee has contributed on wage ceiling, where he is not contributing on higher side. So however, department has not provided the clarity on this particular subject when we have requested several times or when we have raised it. But however, on the other side or with other source, we got to know for such category of employees, department is not entertaining or department is not approving any higher pension. So such category of employees will not be eligible for the higher pension. So move on to the question number 15. What if employee had a break in service during his or her entire EPF and EPS membership prior and after 1st September 2014? Whether such category of employees will be entitled for exercising their higher option? Yes. If the break in service only, there is a break in service where he was not having any employment during the break in service, yes, such category of employees can also go for a higher pension, provided the entire amount, the previous organization, the accumulation have to be transferred to the current organization. The break-in service will be considered as a non-contributory payable days, which is NCP days will be called it. So the department will calculate for the period, for the remaining period will be calculated as a non-contributory payable days. What if employee availed partial withdrawal? So this is one more important question to discuss. Now I exercise the higher pension and I am eligible, and I have been my application has been approved, wherein I have availed the partial withdrawal for a purchase of plot or purchase of house, anything based on what has been prescribed under para 69. So if I have obtained the partial withdrawal, what would be the? So whatever the amount has been withdrawn from the EPF corpus, which is, say, for example, I have withdrawn in 2 lakhs rupees for the purpose of the construction of house. So when the department will calculate how much amount should get diverted from EPF account to EPS, if there is any deficit, as I stated, the partial withdrawal amount has to be paid back to the department, whatever the amount, maybe probably it would be 2 lakh or more than 2 lakh, because your EPF corpus will earn the interest, which is 8.5% or 8.1% currently. So the entire the interest part also department will calculate, and they will deprive the benefit of the interest, and remaining amount has to be paid back. So this is one more query being raised several times. So I would request you to make a note of it. You will, like, such category of employees have to pay back the amount to the department. Does the employee has the additional contribute 1.16% of his salary? So all this till today, like from till the judgment of 4th November 2022, where employees were contributing 1.1%, those who were contributing on higher side. So even the Supreme Court has stated that the EPFO has to provide the clarification. Otherwise, if employee is willing to contribute, even now they can contribute. But however, what we would suggest is, since the Supreme Court has kept it on abeyance, or they have held it for 6 months, so we would request you to hold for another 6 months. Once the department provide the clarity how this 1.16% has to be paid by, who has to be paid, the department has to provide. Accordingly, the employer or employee can take a decision. Move on to the question number 18, whether exercising higher pension by eligible employees are mandatory. So this is one more question, whether it is mandatory. No, this is not mandatory. It is an optional. It is an employee wish based on the corpus, how much he is holding it in the EPF account and how much amount the higher pension is going to get it, he or she, as per the calculation I have provided. So it is optional. So if employee willing, or if he is getting benefited from this higher pension, yes, you can choose it. Otherwise, it is not a mandatory, it is optional. What is EPS calculation formula, which I have also mentioned in my previous slide? Last 16 months average EPS wages, like the PF wages. For example, if you are contributing on 40,000, as I stated in my table, 40,000. The last 60 months, how much was the wage? From there, the average wage will be arrived, and into number of years you have served, which is again divided by 70, which is the lifespan. So these are all the frequently asked questions we have covered here, the major questions. I think I have covered a major of your questions from this, the frequently asked questions. The next slide is related to what employer has to do. As I mentioned, you have to go and intimate your internal employees, those who are working in your organization, and you can also intimate your employees who have retired if required, or if such employees are reaching out to you, understand whether they were contributing on higher side, and if they're contributing, and you have to intimate how the higher pension has to be exercised with all this information. And as I mentioned, the due date has been extended to 3rd May 2023. So these are all the immediate action has to be taken care by employer. In addition to that, what I would like to highlight it, the para 26.6, as I stated. So if you can approach department, and if you get this 26.6 joint consent submitted, so that would really help your employees to opt for a higher pension. Sumit, I think we are done with the presentation. If you would like to add something.
Yeah. Any questions you would want to take more from the Q&A box? Mahesh, 1 or 2?
Definitely. There are 26 questions are there.
Yeah, please.
If an employee joined the organization. So the first question is related, if an employee joined the organization on or before 1st September 2014 and PF contribution is on actual basic and pension deduction was on statutory limit. As I mentioned, yes, such category of employees will be entitled. They can opt for a higher pension now. And the second question, can you explain the basics? I mean, what happens when we pay some amount to as PF, how it is divided, and what is the changes? The query is not clear. I'll jump on to the next query. What is meant by higher wages? I meant by higher wages that there are companies there, the PF, the applicability or the PF, there is a capping under Employees Provident Fund and Miscellaneous Provision Act 1952 is applicable those who are having basic wages or the PF wages of 15,000 and less. Anything beyond 15,000, it is not mandatory to contribute on a beyond 15,000, or those who are even employees, or it is a first-time membership and whose PF wages or basic wages more than 15,000, it is only optional for them to be covered under PF. Otherwise, it is not mandatory. So that is when those who are contributing on actual basic wages, only such category of employees will come into the picture of higher pension or the higher wages. So someone has raised, this is anonymous attendee, so they have not provided the details.
So maybe what we can do is, Mahesh, we can compile this. And what
Yes.
my request to the participants is that this is a very, very important next step. And if there is anything, please write back to us. We will try our level best to help you with your queries. And also from time to time, we will organize these sessions. And if there is any specific requirement of your organizations, we are helping certain organizations to create a better clarity. And the next steps for the companies, will be more than happy to help your organization as well. So please write to us. Please feel free to write to us, and we'll try to help give responses in a quick turnaround time on that.
And Sumit, what I would like to also add here, we are planning to upload our questionnaire FAQ in our website.
Mm-hmm. Yeah, that will also be helpful.
Yes, yes.
Great. So thank you so much, all the participants, and thank you, Mahesh, and look forward to another such session on another interesting topic, which will be value adding to each one of us from the compliance and the HR perspective. Thank you so much.
Thanks everyone.